During a recent Senate hearing, Dr. Anthony Fauci declined to answer over 100 questions, repeatedly invoking his Fifth Amendment privilege. This led Sen. Rand Paul Archive, chair of the Senate Homeland Security and Governmental Affairs Committee, to announce his intention to pursue contempt proceedings against Dr. Fauci. The matter has raised significant legal questions regarding the intersection of presidential pardons and the Fifth Amendment. Dr. Fauci was granted a full and unconditional presidential pardon by President Joe Biden for actions taken between January 1, 2014 and January 19, 2025. This pardon insulates him from federal prosecution for the conduct under review by the committee, with the exception of potential perjury if he provides false testimony under oath. Legal experts have noted that the situation presents a novel issue. Abhishek Kambli, a former Justice Department official now representing a former Trump advisor in a contempt of Congress case, stated that if Dr. Fauci provides truthful testimony, the presidential pardon would shield him from prosecution regarding past conduct, thus potentially negating the grounds for Fifth Amendment protection with respect to those actions. Kambli also highlighted that the Fifth Amendment protection becomes less tenable in response to straightforward factual inquiries that do not carry a risk of self-incrimination apart from perjury. Kambli further differentiated between witnesses who completely ignore a congressional subpoena and those who appear but decline to answer specific questions. In the latter case, the central question becomes whether the refusal is based on a legitimate legal principle, such as the Fifth Amendment. Jonathan Turley, a law professor at George Washington University, observed that the complexity of the legal issues at play is considerable, particularly concerning whether statements made in an opening statement prior to invoking the Fifth Amendment could affect the legitimacy of invoking that right. He referenced the precedent of Lois Lerner, a former IRS official who delivered an opening statement and subsequently invoked the Fifth Amendment during a 2013 hearing, leading to an unresolved debate about whether that constituted a waiver of her rights. Hans von Spakovsky, a senior legal fellow at Advancing American Freedom, supported the view that the presidential pardon protects Dr. Fauci from federal prosecution for actions taken during the covered period, but emphasized that it does not grant immunity from perjury if false statements are made under oath or from potential state-level charges. However, von Spakovsky noted the improbability of state prosecutions, given that Dr. Fauci's actions were undertaken in his official federal capacity. Should the contempt resolution advance from committee, it would proceed to the full Senate, where it would require at least 60 votes to overcome a filibuster. At the time of reporting, Dr. Fauci's legal counsel had not provided comment. Want to make sure you never miss our latest videos? Tap that follow button right now. If our content brought a smile to your face, made you think, or taught you something new, please like this video and share with your friends and family. Your support helps our community grow, and sharing the love only takes a second. Thank you for watching and being part of our journey.